Hi, everyone, and Happy New Year. I'm Luke Bowery, Head of Employment here at Burgess Salmon, and I'm joined by Kate Redshaw, one of our senior lawyers.
Hi.
Given the Employment Rights Act is now finally landed, we wanted to give you a whistle-stop tour of the key changes coming up in 2026 so you're ready for what lies ahead. Kate's going to kick us off.
Thanks, Luke. So, April is when the first wave of key reforms will hit, with statutory sick pay in the spotlight. The lower earnings limit gone. The 3-day waiting period also gone, with SSP applying from day one of absence. With more employees qualifying for SSP and earlier entitlement, this reform has big budgetary implications for some employers. Next up is family leave. While unfair dismissal won't be a day one right, employees will be entitled to paternity leave and unpaid parental leave from day one of employment. So update those policies and make sure your line managers are briefed. And if you're planning redundancies where the collective consultation obligations will apply, take note. The maximum protective award for breach of the legal requirements doubles to 180 days uncapped pay per affected employee. Finally, for April, trade union recognition gets easier, so some employers can expect more activity on that front. So that's April's changes in a nutshell. But Luke, what is happening in October?
Well, October is also packed with changes. First of all, harassment. Unless you've taken all reasonable steps to prevent it, employees will be able to bring claims if they're harassed by a third party whilst they're working. Customers, clients, members of the public are all third parties, so you need to review your risk factors and take steps to mitigate them. On a similar note, the duty to prevent sexual harassment is also changing, and you'll need to take all reasonable steps to prevent harassment in order to comply. Next, fire and rehire. The government promised to end this practice, and the ERA largely delivers. From October, other than in exceptional circumstances, you won't be able to change certain terms of employment, including pay and hours, without employee agreement. It's complex, so if you're planning changes, get advice well in advance. From October onwards, trade unions could also become regular visitors to your workplace. New rights mean a trade union, through an access agreement, will be able to meet staff and recruit members either physically on your premises or via digital access. Plus, you'll need to inform workers of their right to join a trade union. And one more for October, the time limit for bringing employment tribunal claims will double from 3 months to 6. Finally, and sneaking a peek beyond October, it's the big one. In January 2027, unfair dismissal protection will attach after only 6 months' employment, but planning for that needs to start now.
So that's our quick tour of the ERA changes for 2026. Do appreciate it's a lot to take in, but don't worry, our new Employment Rights Act website hub, not very easy to say, has resources and guidance designed specifically for employers. And to get you off to a confident start, please do join us for our ERA webinar, which we're hosting on the 20th of January. And details for that and how to register are also on the hub. Thanks so much for watching, and we hope to see you soon.